Hi, my name's Scott Bowman. I'm a partner at McDermott, Will & Emery in Washington, D.C., and I'm going to spend the next 15 to 20 minutes talking about the use of a life insurance trust for purposes of holding life insurance in a cross-border estate and tax planning situation. So my understanding of the typical facts that you may face is that we have a non-U.S. citizen who's not resident or domiciled in the United States, but may have investments or assets that are located in the United States, may have a spouse, children, or other beneficiaries who are in the United States, and is trying to acquire life insurance in the United States. Now, why in this fact pattern do we very often see the non-US person interested in acquiring a significant life insurance policy? Well, first of all, oftentimes there are non-US considerations that drive this. So for home country purposes, economic, political, security related, those considerations may be a driver for a family acquiring a significant life insurance policy. But specific to the United States, we typically see two significant issues. The first is concern about US estate tax exposure. So take, for example, a non-US person who purchases directly an interest in a $5 million piece of US real estate, a residence, let's say. If that person owns that residence and then dies, that person will face an approximately $2 million estate tax on the value of the $5 million residence. That's because the United States imposes a 40% estate tax. And when one is not domiciled in the United States, the non-domiciliary who's not a citizen doesn't benefit from the larger U.S. estate tax exemption. So for a citizen or for a domiciliary, that exclusion amount is just north of $12 million. But in the case of a non-citizen who's not domiciled in the United States, there's a mere $60,000 exemption amount available to offset the estate tax exposure on U.S. situated assets. So that's a really main driver. Additionally, from the U.S. tax perspective, non-U.S. families may well have investments outside of the United States that can be problematic for a U.S. beneficiary to inherit. So the U.S. has a set of very complex cross-border tax regimes. We refer to them as our anti-deferral regimes that include what we call a controlled foreign corporation or a passive foreign investment company. And those types of companies, if inherited by a U.S. beneficiary, can be particularly problematic and tax inefficient. And so sometimes we will see multi-jurisdictional families acquire a large life insurance policy as a way to supplement or substitute an inheritance that a U.S. beneficiary might otherwise receive in the non-U.S. investments. So again, we're looking at acquiring a large life insurance policy for one of these purposes. And the question then becomes, how should that policy be owned and why? Well, the most common way that life insurance is owned in the United States is through a pretty simple technique referred to as an irrevocable life insurance trust, or an ILIT. So an ILIT is a very common technique used in the purely domestic context for U.S. citizens and domiciliaries to own their life insurance. Well, why is that? It's because the death benefit payable on a life insurance policy of a U.S. citizen or U.S. domiciliary would be included in that person's estate and therefore subject to estate tax when that person dies. Now, where the insured or the owner is a non-U.S. person, a non-U.S. domiciliary, we need to think in a little bit more detail. that's because the rules provide that if you're the insured, you're not domiciled in the United States, that death benefit should not be considered U.S. situated property in the ordinary course. And so, technically speaking, this irrevocable life insurance trust might not be required. Nonetheless, it's a very common practice, and I think a matter of best practice and best advice to think about putting a trust like this in place. Why is that? First of all, using a trust like this can facilitate the underwriting process. We'll overwhelmingly have a U.S. person as the trustee of the trust. And so that creates what we call nexus, which is a legal term for a relationship to a particular jurisdiction, a state in the United States, that then allows the insurance to be underwritten in that state under that state's insurance law. So that's a really great reason if one is trying to benefit from the use of a US-based product. Second is the use of the life insurance trust can facilitate the payout of the death benefit. Trusts are an important vehicle in U.S. estate planning because the assets that are held in trust don't pass as part of our probate process. And so making sure that the policy is owned by a trust and the proceeds are distributed to a trust means that the death benefit isn't going to be locked up in some type of multi-jurisdictional, multinational succession process. It creates efficiency and streamlining to get the money to the heirs in a much easier and quicker manner. Additionally, holding the death benefit, the life insurance proceeds in trust for the benefit of beneficiaries who are in the U.S. achieves a couple of really important objectives for them. If the beneficiary inherits the death benefit directly and has a meaningful estate of his or her own, when that beneficiary dies, the death benefit that's been inherited is going to be part of that person's estate for estate tax purposes, and then may be subject to U.S. estate tax at that time. If the trust is structured properly, the assets can be held in trust and therefore not includable in the estate of the beneficiary when the beneficiary dies. Additionally, assets that are held in trust for the benefit of a beneficiary should be protected from the claims of the beneficiary's creditors. Now, whenever U.S. lawyers talk about this issue in a non-U.S. context, there's initially, I think, some reticence to find this creditor protection aspect compelling. That's because litigation around creditors' issues in non-U.S. jurisdictions is far less common than it is in the United States, where anybody can sue anybody for anything, and protecting the assets within the family structure for the benefit of the intended beneficiaries is overwhelmingly a critical estate planning objective in the United States. This is particularly so as we think about beneficiaries who may not yet be married but be getting married in the future, and we're concerned about protecting the assets in the event that the beneficiary were to ever become divorced. So with all of that said, the importance of using a life insurance as a way to reduce or pay ultimately for a U.S. estate tax liability where there are U.S. situated assets and a lower exemption amount is available, as a way to create some income tax efficiencies for passing cash or liquid assets to a U.S. beneficiary where the family may otherwise be invested in tax inefficient assets if owned by a U.S. beneficiary. And also the importance of using a U.S.-based ILIT, the life insurance trust, to own the policy. Let's talk briefly about what this trust might look like. First of all, it's irrevocable. That means that the person who creates the trust, who we call the settlor or the grantor, cannot retain the power to revoke the trust and get the assets back. It doesn't mean that we can't build in flexibility to accommodate modifications or amendments in the future. It's simply that our process for doing that can't rely on the grantor or the settlor having the power in his or her hands. We typically include an independent person, generically referred to as a protector, who may have the ability to make amendments or modifications to the trust in the future. So who then are the beneficiaries? Well, we define the beneficiaries by class and not necessarily by name. So we like to refer to the grantor's descendants, oftentimes the grantor's spouse as well, so that as additional individuals are born or pass away, the class of beneficiaries is dynamic. But what's important to keep in mind is that only the beneficiaries contemplated by the trust instrument are the beneficiaries of the trust. So it's not like a stranger can show up and make a claim to be the beneficiary of a trust. The last person who's critical in the overall puzzle pieces of the islet is the trustee. Now, if you don't come from a U.S. legal background or a background that has trust law, the idea of the trustee is a little bit strange. What the trustee does is own the assets of the trust in a legal sense, but not in a beneficial sense. So the trustee is responsible for investing the assets, holds legal title to the assets, opens the bank accounts, authorizes trust distributions, files the tax returns, all of the things that you would think of as administrative or investment related and ultimately related to distributions to beneficiaries. Now, the trustee in the capacity as trustee is not a beneficiary, which means the trustee can't just take the money and run. That would subject the trustee to a claim for breach of trust under the law of any state in the United States. That's not to say that an individual can't be both the trustee and the beneficiary. In fact, this is very common in many ILETs and other trusts drafted for U.S. tax and estate planning purposes. The beneficiary may act as a trustee of the trust, and in fact as sole trustee of the trust, provided that certain important language from a U.S. tax perspective is included. This language is overwhelmingly related to two material categories. First is the distribution standard. So if a beneficiary is acting as trustee, the distributions must be limited to the beneficiary's health, education, maintenance, and support. The beneficiary as trustee can't just distribute for any reason that he or she chooses. Otherwise, the beneficiary is treated as owning the assets for estate tax purposes and also very often for creditor protection purposes. Second is the beneficiary or the trustee can have the ability to appoint successors or to remove and replace trustees. But in doing so, a beneficiary should not be given the power to remove a trustee and to appoint a successor trustee who's related or subordinate to the beneficiary who's making the appointment. The last comment that I'll make is that when we draft trusts from a U.S. legal perspective, we're very often focused on the duration of the trust, which is how long can the trust last for under the applicable state law. If you rewind several centuries to the creation of trust law in England, there was a rule known as the rule against perpetuities, which held that trusts could not last for perpetual durations, meaning they needed a definite and finite ending date, and that ending date was prescribed under the common law, the law of England. In the United States, as well as many other non-U.S. jurisdictions, trust law has evolved to override this old English rule against perpetuities to allow trusts that have much longer durations. In fact, in many U.S. states, trusts can last forever. So if the value of the assets is particularly significant, maintaining the assets in trust for an extended period of time can perpetuate the benefits of estate tax savings and creditor protection. And so in choosing a trust jurisdiction, you want to ask whether the jurisdiction is one that permits perpetual, or what are oftentimes referred to as dynasty trusts. So that's the essence of planning around a life insurance trust to hold life insurance on the life of a non-U.S. person. Again, my name is Scott Bowman. You can find me on the web at mwe.com, and you can contact me by email at sbowman, SBOWMAN, at MWE.com. Thanks so much. Bye.